Good morning, ladies and gentlemen. It is with great enthusiasm that we take part to this international event regarding ELSA Day. My name is Domiziana Delle Monache. I am from Padova, Italy. I'm currently Vice President for Seminars and Conferences of ELSA Padova. I'm so glad that we can participate to this special day, particularly as it has been organized by ELSA Deutschland. We are the only local board in Italy to be present today, and it is with big honor that we will represent not only our local team, but the entire ELSA Italia group. So we're going to talk about Technolaw and human rights, nature and limits of the digital challenge. Today's lecture is on AI, artificial intelligence, tech law, and the challenges and opportunities that arise from them when it comes to human rights and ethics. Our speaker will be Professor Paolo Moro, lecturer at the University of Padova. So I leave therefore the word to my colleague Sofia Casagrande, Director for Seminars and Conferences, who will introduce you Professor Paolo Moro.
Hello everyone, I'm Sofia. I'm the S&C Director for ELSA Padova, and I'm honored to introduce you to our speaker today. Paolo Moro is a Professor of Philosophy of Law at the University of Padua in Italy, where he also teaches methodology of law and legal informatics. He has been a lawyer for 25 years now, and he is currently the president of the degree program in Law 2.0 at the University of Padua, where he plays a significant role in innovating the way his students learn the law. At the end of the talk, Professor Moro will also tell us about one of the ways we can delve deeper into the topic of tech law, so make sure to stay tuned until the end to find out more. And there will also be time, of course, for a Q&A, so feel free to post your questions on YouTube. And with that being said, I give the floor to Professor Moro, and thank you for joining us.
Thank you very much for this presentation, for this invitation. I'm very delighted to be here. My topic today is Technolaw and human rights, and I will speak about nature and limits of our digital challenge. We can speak about this topic, but here I leave my email address for questions afterwards, in case of questions, in case of every doubt for my presentation, about my presentation. I have the screen, yes, and in presentation is okay. Yes, I can. I have the starting point because my starting point in my topic is legal informatics. What is legal informatics? We can understand that legal informatics studies the logical foundation and the application of information and communication technologies in the legal activities. Legal informatics is not only Technolaw or computer science and law, is not only a group of norms, but it's important to say firstly that legal informatics is a subject that studies the logical foundation, and it is an activity, and is an activity that is similar to technology. And secondly, legal informatics evaluates the ethical and legal impact of convergent and exponential technologies in law. Legal informatics is the starting point of my presentation, because this is the method of my presentation. I prefer use the terms convergent and exponential in technologies, because legal technologies are of course new, but innovation is not a characteristic of Technolaw. The real innovation is that legal technologies nowadays are convergent and exponential. Convergent because there are some technologies or some legal technologies which are coming closer together, and exponential because there are some technologies and some legal technologies which rapidly increase. And this is fundamental to understand my point of view about legal informatics and about the relation between artificial intelligence and law. I think that today we live in a computational growth, and Technolaw is the second point of view of my presentation. Technolaw is not only a system of rules, but as, for example, a computational system, because the algorithms of every computational system establish norms, and they cannot measure the variability of the value conflicts, e.g. biases, discriminations, fake news. This is very important today for ethics and law, but the same algorithms are norms, and there are technical norms, legal norms, ethical norms. But today the power of algorithms measures this computational growth. Secondly, Technolaw is overall a legal methodology. And methodology is a technology. Technology is methodology, and methodology is technology. And this legal methodology must resolve human conflicts. And legal technologies that today are disruptive. Of course, we know this term disruptive in Technolaw, but Technolaw is overall a methodology. And the legal choices imply reflection and decision-making ability in uncertain and controversial situations. It's very important. The alternative dispute resolution today, and very important, is the online dispute resolution that are the future of the legal proceedings and the new form of the trial of every kind of trial in law. Thirdly, Technolaw, that is also a group of norms, domestic norms, national norms, international norms, but the sources of norms are not only codes, and in this there is sentences, there is judicial decisions, and Technolaw might become indeed a judgment technology between opposing theses that are always defeasible. And this is very important because algorithms, every algorithm must be questionable and can be defeated by opposing arguments in law. And this is the real question of artificial intelligence, because algorithms are a sequence, and algorithms, every algorithm starts from an hypothesis, a premise that we cannot discuss. And this is the real question of the contemporary era. Why we can decide, why we can choose the best way to use this computational growth. Technolaw, ethics, technoethics, Technolaw have today many questions and have many answers, of course, in this respect. What is the other questions? The first question today in this sense, the paradigm shift. The paradigm shift today is about artificial intelligence and global internet. The big technologies that are also legal technologies, and that are also two methodologies. But today we leave another artificial intelligence. We live another internet, because artificial intelligence is from human-made representations is going from human-made representations of knowledge to data-driven machine learning. The big use of machine learning today establishes that we are in artificial intelligence in another paradigm, and this is very important for law. From logic to statistics and neuroscience, today the use of statistics in artificial intelligence in the last 3 or 4 years is huge, and artificial intelligence is connected today to global internet, not to internet as a domestic network, but the interconnected network. The meaning of the word internet is, of course, global. And in global internet, we are going from a system for human communication to a global interconnected data system. The big data are inside global internet. And then we are going from passive information to active algorithms. And this is the technological question. The first technological question is the paradigm shift. And the changing is a challenge, of course, because artificial intelligence and global internet are connected today. Artificial intelligence works in global internet, and global internet works with artificial intelligence, by artificial intelligence. But in the science, in the computer science, we have this step from logic to statistics, from theory to practice, from passive information that we can read in internet to active algorithms that are working today, always in internet. And internet is working with artificial intelligence and by artificial intelligence systems. Then we can have this situation. Today we live in the huge convergence, also legal technologies, but what are the two technologies, the two big and strong technologies, AI and GI, artificial intelligence and global internet. But how is the huge convergence? What AI wants? AI wants today a larger set of examples, a larger set of data. And the big data, the biggest data to discover new correlations are in global internet. What internet wants? What the internet wants? Intelligent services and individualized solutions wants the global internet. The ability then to extract useful knowledge from data. This is very important because the ability to extract useful knowledge is in the artificial intelligence. The ability is not human. The ability is on the robots, about the robots. And the bots are today a big power, absolutely. Conclusion of this reasoning is the powerful AI enables the internet to exploit the data, and the rich internet provides AI with data. Today, AI and GI are connected. There is a link about this. This is very important in the innovation technologies, in the innovation of technologies, but it's very important in the legal technology. For example, internet is also a legal technology. I can use internet to search legal sources, for example. Or for instance, I can use AI as a legal technology, because AI is also a legal technology. For example, to search and to extract, to select, to evaluate useful legal knowledge, legal sources, norms, decisions of judge, or other sources that I can use, for example, to search. And this is the origin of legal informatics. Legal informatics has an origins in jurimetrics in United States in 50s of last century. And the powerful AI is connected to the internet because enables internet to exploit data. And this is very important because internet is always rich of data. Big data and in global internet, artificial intelligence with machine learning. This is the fundamental convergence, and this is a huge convergence today. And we are going to the exponential convergence of AI and GI. We can have another step. The step what is for a law, for a jurist, for a lawyer, the ethics and legal impact. This is a question very discussed in the contemporary era. Nowadays, we can speaking everywhere and every time about ethics and legal impact of AI and GI. Three fields I think that are important in ethics and legal impact. I think that ethics and law are a unique word, absolutely. In the ancient time, there is no doubt. In the modern time and in the contemporary era, we have some doubt of this. But I think that ethics and law are a same word. Three fields of impact. First of all, business ethics. It's very important. By 2018, 50% of violations of business ethics will be performed by algorithms. This is a Gartner report in 2016, but by 2020, I think that 80% of violations of business ethics will be performed by algorithms. You can say about financial markets, by the algo trading, for example. We have many issues about business ethics and law in this field. Second field, this is typical of commercial law, the market power and the natural monopolies. Competition is neglected today. We have the big five in United States that, but not only United States, of course, but the big five in the world, I think in the contemporary era are killing competition, because competition is a value for economics, for business, for ethics, and this value is very important to preserve, of course, the economy, the market, in a real way. Thirdly, the topic of this event, I think, fundamental rights. AI and GI have an ethics and legal impact, a huge impact against fundamental rights. Absolutely, many examples of fundamental rights or violation of fundamental rights about these disruptive technologies. Fundamental rights as privacy is this is natural, is of course is privacy, because in Europe we have the GDPR, and the GDPR is a shield against the power, against competition of, for example, the big five of the companies, of the corporations. And Europe has about the general data protection rulement has created a shield, a legal shield. And we have a huge question, the huge legal issue is this: freedom of expression. Of course, freedom of expression is a fundamental right, but the violation of freedom of expression about, for example, fake news or hating speech are a violation of freedom of expression. And this is another issue as non-discrimination. This is the power of algorithms. Artificial intelligence create discrimination in many fields of application. Absolutely, in job, in the right to study, and other fields. Fourthly, the most important field of fundamental rights is the fair trial. The fair trial in the in Europe, for example, is very important. And in fair trial, we have many fundamental rights. For example, the rights to have a fair trial is a human right, is a fundamental right, and this is in danger because algorithms, AI, the bad use of global internet can close the principle of fair trial, the legal principle and the ethical principle of fair trial. And finally, human dignity. Human dignity is in danger, and this is the real challenge of the use of technologies and the real legal impact of this about the fundamental rights and the value. Human dignity is the fundament of human rights in all in every norm, in every chart, in the International Code of Human Rights. We can say this because we know that especially in Europe or especially in the United States of America, algorithms, AI, the use of internet today is very important, but it's very important the protection of fundamental rights, and this is the typical legal issue. Ethics and legal impact ask a legal remedy, the legal remedy or an ethical remedy, because we need a new law, of course, for AI and for GI, for global internet, but it's not enough to establish norms, to establish positive norms. We can say that the GDPR works, but it doesn't work enough to protect competition, to protect business ethics, to protect fundamental rights. I think that there is a legal remedy that is also an ethical remedy. This is the fair play principle. I use these words, fair play, that of course represent a sports principle, a principle of the sports activity. But fair play is legal. Fair play are legal words, because the fair play principle is we can apply fair play principle, for example, in fair trial. Fair trial is the same term. Fair trial, fair play. Fair trial is a fair play. And there are, of course, three fields of application of fair play principle as legal remedy of this power of AI and this power without limits of global internet, because AI works by machine learning. And machine learning is a strong way of technology to connect to global internet, and internet as, of course, big data. And machine learning and big data are a mystery. Informatics, technical experts the experience demonstrates that we have a mystery in AI, machine learning, and in GI, big data. We have a limited knowledge of this. I think that this legal remedy, we can apply this legal remedy, the fair play principle, in, I think, 3 fields of application. Firstly, in competition law, I think that this is the most important part of commercial law, competition law. In competition law, we say that it's very important fair play, fair competition, consumer welfare. Fair competition in competition law is against the natural monopolies or the big monopolies. And this is very important in competition law and in the digital world. Secondly, data protection law. Of course, the most important part of law in Europe is data protection, because GDPR is the first example of the shield to protect human rights, to protect privacy, and to protect the personal data in the global internet, in the big world of global internet, but also in the big world of AI. Lawfulness, transparency, confidentiality are the fundamental principle of data protection law. It's very important to understand that data protection law as the fair principle, the fair play principle, the fairness as the principle of every norm that we can discover in data protection law. Lawfulness, transparency, confidentiality are phenomena of fair play principle. And thirdly, the principal example is the fair trial, of course. Fair trial as inside the fair play principle. We can use the fairness as a legal and ethical remedy, I think, in every activity of fair trial. The same name, fair, is the same word. I use fair as in fair trial as the fair play principle. Fourth party, ethics in technological proceedings and in ODR machine-based. I think that the future or the present is the ODR, online dispute resolution, and we can apply the fair trial in ODR. We can have some issues because ODR is machine-based, and the third party, the judge, can become a robot. When we have a robot in fair trial, of course, we can use the fair play principle, I think. But when the third party or the fourth party that is a robot, that is a bot in a trial that is a judge, in technological proceeding, we must use the ODR machine-based in a legal way, because the machine learning is ruled by algorithms, not is ruled by a law or a constitutional principle. And this is very important for the present and the future, because AI and GI are increasing in a huge way, absolutely. Competition law, data protection law, fair trial are 3 examples, are 3 roads that we can examine about the fair play principle. We have 2 open issues in this situation, I think. There is a GI open issue, and this is a legal issue, of course, and there is an AI open issue. What is the GI open issue? The right to be disconnected, I think. An opposing exercise of power is the principal solvent of economic power. John Galbraith wrote this in the concept of countervailing power, the basic defense against its exercise in economic affairs. This is the basic defense, and the opposing exercise of power of algorithms is possible, an opposing exercise of against the powerful of AI, of GI. Yes, it's possible, and it's legal. To enable civil society to achieve in free and legal democracy, wrote Hannah Arendt in Civil Disobedience, we must guarantee not only an aware consent, but also a free dissent. In our society, we think that consent is the legal base of violation, for example, of privacy. Privacy is consented, and we think there is no question, there is no issue. No, the real free society lives when we can guarantee a free dissent, not a free consent. And this is a legal dissent. Civil disobedience is a legal dissent. But the Technolaw system is valid not only when it protects by positive norms. We can think that positive norms are the legal remedy. No, I think that the principle, not the single norms, but the general principle of fair trial is a sort of ethical, end of the Technolaw. Not a technical norm, a technical rule. And by positive norms, the right to internet access, I can that this is the first question. No, when I use GI, global internet, the Technolaw system, global internet is valid, and the Technolaw has also a group of norms, of course, when it allows the possibility of its overcoming. It allows the possibility of dissent and its overcoming, that is the right to be disconnected from the global internet. When I listen, when I read, for instance, Jason Lanier, that is the guru of the Silicon Valley, that says out of Facebook, out of Instagram, out of the social network. This is the social dilemma we have to Netflix in this period, and very interesting issue about the right to be disconnected. Can we live without the global internet? This is the legal and the ethical issue of our era, because technology is very important. But we must preserve the right to be disconnected from GI. And this is today an open issue. We must speak about the right to be disconnected, I think, from global internet in our era, because this is a fundamental right. The fundamental right in GI is also the right to be disconnected, not only the right to internet access. Of course, United Nations teach us that it's important, the right to internet access, but on the contrary, it's very important, the right to be disconnected by internet. And when I allow the possibility of its overcoming, I am in a valid legal system. I am in a system that consents the dissent. What is the AI open issue? What is the authentic open issue today? I think that AI, machine learning, robotics has this issue. The bio-robotic interaction, the most important issue, the most important question that we have between law, between ethics, between informatics, between robotics, is the interaction between human and robots. AI, indeed, AI invades human identity through the interaction with the most evolved technological devices. And the most evolved technological devices are the devices of biorobotics, bionic systems of artificial intelligence inside the human body. We have the world today of Internet of Things, but IoT is not only objects, external objects. Bionic system inside the human body of artificial intelligence creates a new human identity. This is the huge innovation. Biorobotics is a new science, but biorobotics creates bioethics problem, and bioethic problem are in biolaw. Biolaw is a new subject, is a new science today. And the biorobotic applications to the human body may become a treatment harming human dignity. Article 1 of the Charter of Fundamental Rights of the European Union. In Europe, it's very important, this human right, and this is the fundamental of human rights. The fundament of human right is human dignity, of course, Article 1. Physical integrity, identity, human identity is not only in the human dignity in general, but in physical integrity. Where is the human body if I need the explosion of biorobotics, of devices? This is the typical issue of the dual use research. I must use in ethical meaning, I must use research in science in two ways. For to create a wellness for body, but also a bad body. I don't know, but this is the fundamental issue for human rights. And of course, third issue in biorobotics applications is privacy. Article 8 and GDPR. Article 8 and GDPR are important group of norms, Article 8 of the Charter of Fundamental Rights in the European Union. But privacy is today the real most important right, we can say, because in Europe we have GDPR that is very strong in privacy, and this is a legal shield very strong that is not an easy way to create business, for example, for the US companies or for the China companies in Europe. And this is very important. But I think that biorobotic interaction, because the interaction between human and robots and the biorobotics are the fundamental issues and other fundamental sciences in the contemporary era to study law. I have a place for debate in conclusion, to suggest you. This place is our new scientific review, the Journal of Ethics and Legal Technology, that Padova University Press publishes. This new review. We have 3 issues in this moment, and within a particular declination of philosophy of law, the journal publishes contributions and reflections about ethical and legal issue in a cross-disciplinary way, and legal issues of technological challenge in this third millennium, with particular attention to legal informatics, the starting point of my presentation, information technologies that are methodologies, robotics, artificial intelligence. The authors that are scholars, of course, of this journal present their works here and are called to reflect critically in a free and a cross-disciplinary way about philosophical, logical, ethical, cultural aspects of Technolaw. Technolaw is not only a group of norms, but Technolaw is also a methodology, also technology. and technology is very important in the contemporary era. And this is the legal experience in the technological dimension of contemporary man. Journal, of course, adopts a double-blind peer review process for acceptance. Also students, also PhD students can publish here a paper. But I think that it's very important to read this, the first, the second, the third issue of our journal, because we have three focus about the most important dilemmas in the contemporary era. The authors are not only jurists, are also informatics, are also scholars about physics, scholar about philosophy, and we can create, we would like to create a real place for debate about these themes, these theses. Topics of particular interest for every issue, for instance, are methodological compatibility between the discipline of computer science and law, and the discipline of law, or analysis about fairness, accountability, transparency, ethics in machine learning and data mining, or legal informatics, online dispute resolution, theoretical foundation and ethical consequences of the right to be disconnected. We think that these are the fundamental topics of the Technolaw. I prefer this term Technolaw because computer science and law is not enough to create a real and interesting meaning of this. This is a place for debate and a place for reading, a place for writing, of course, and you can read the address, the web address here. It's JELT in the web page of Padova University Press of our university. Allow me a final reflection about Technolaw. Computer science and robotics and artificial intelligence, of course, are the forms of technology that have determined the most revolutionary social transformations in the contemporary era. I spoke about the exponential acceleration of technological innovations, but this acceleration seems now to have surpassed the possibility of science, the possibility of science to reflect or to elaborate a theory about it. Science today is weak. Indeed, the crisis of Western science has shown, I think, that perhaps we wrote this in the home page of our journal, because we think that the crisis of Western science has shown that perhaps science itself is not an irreversible conquest, but a singular historical event. Science is not always, but science is only in the modern era, only in the historical modern era, and limited. Science is limited in time and space, while technology, not science, technology, the technological approach to knowledge maybe is the original form, may be the original form of apprehension of reality and a structural part of man's essence. We think that technology is more important than science. We need science, but technology is the essence of man. And nowadays, we think that this is the task of philosophy. Philosophy of law is the real field of debate, is the real place for debate. And this is the importance of philosophy in law, because philosophy is the first is the first subject, is the third field of discussion and of debate of these issues. This is my conclusion. Thank you very much for attention. Of course, I am here for some question. Thank you very much to Sofia, to Domiziana, and for everyone.
We're just waiting one moment for the questions to arrive. Okay. So the first question is our mindless collection of data today going to pose a risk for the AI solutions of the future?
Must I answer immediately, or one question?
I think you can go on with the next question. Would AI be able to reflect the concrete circumstances of an individual case in a trial, or would it only decide according to previous decisions?
Yes, it's very. These questions are complicated, but I must be short. AI, yes, AI is able to reflect the concrete circumstances of a case in a trial, but it's very difficult because the logic, the methodology of decision making, the logic, according to previous decisions, today I think that is only human. Only a human judge can decide this. Only a human lawyer can search a precedent or studies a case in a trial. Many AI systems today are working according to this way of method, this methodology. But this is, I think that this is the real issue, because AI, machine learning are formal logic, are based in a formal logic. Law is based about an informal logic. Argumentation, for example, is the first question that we can use AI. Can you come back to the top question, to the first question, because I don't. Is our mindless collection? Yes, and about the collection of data, yes, going to pose a AI solution. Yes, our mindless collection of data today, yes, is going to AI solutions. But today, the AI solutions are ruled by engineer, by informatics, not by lawyers. Lawyers as a method and must study this method. And this method, I think, that is the ancient rhetoric. I study ancient rhetoric in the digital rhetoric, because rhetoric, the ancient art of argumentation, is not useful for AI solutions today. AI solutions of the future, I think, will work about this method. Another question?
Yes, we do have another one. So we say, as the development of AI brings forth a conflict between progress and ethics, when both collide, which would you say has to take the back seat?
Yes, when both collide. Yes. Yes, the development of AI brings a conflict, and the legal and ethics impact is, of course, very clear today. But both, yes, because this is complicated, because the collision of AI, of the development of AI, create many conflicts, and many conflicts are legal conflicts. legal and ethical conflicts. I think that the decision making is legal, must be legal. We must apply the fair trial, and we can create a sort of proceeding decision decision making based on this legal proceeding. Fair trial is a principle that we can apply to this, but I don't know. I don't know when both collide which would you say to take the best. Absolutely, I don't know, because this is a cross-disciplinary issue, and if I have an answer, I must study this in a legal. I must study the legal issue, the ethical issue, the philosophical issue, the technical issue. We must create a group of scientific research about this, because this is not a question. Many compliments for the question, but the question is very, very important. Another question is how important is.
Yes, right. How important is it, in your opinion, to also apply rules of ethics to the collection and usage of the data that then goes on to become the AI's training data?
Yes, yes, of course, very important. Apply rules of ethics, but the question is not if how important it is to apply rules of ethics. Of course, the real question is what are rules of ethics? Which rule of ethics I can apply in AI, in GI? Because today we are speaking about ethics without foundation of ethics, and who says the ethical rules? And of course, the usage of data today in GI is going to the huge growth of big data, for example. But in AI's training in a robot, of course, the ethical issue is robot is a human, is a man or not a man? Because if I use the rule of ethics for man, I don't know if the same rules are I can apply. I don't know if I can apply these rules of ethics to AI's training of a bot. Bot is not only a hardware, is also a software, is not material. AI today, the most important difference between man and robot is the body, not the mind. And we must reflect about the rules of ethics. Is it possible to think a translation, a transfer from ethical human ethics to bot ethics? I don't know. We must study this. Of course, AI exists. We have AI and we have GI, and we must reflect about this. This is the task of philosophy. This is important philosophy of law in this sense. How is AI?
Yes. How is AI threatening the worldwide competition in addition to the general problems monopoles create?
But I repeat that AI in worldwide competition AI creates general problems, general issues. Absolutely. Monopoles are in AI, are in GI, but if we must defend the fundamental principle of worldwide competition, AI creates a problem for this, because this is I think, but in this field, this question, I posed this question to my colleague of commercial law. My colleague that studies commercial law must answer. to this question. I believe that commercial law is competition law in the contemporary era, and AI. Then a code, an existing norm, a judicial precedent doesn't resolve this this question. I don't know if it's possible to search answers in the positive norms, in the positive norm of nowadays. Absolutely, this is very interesting. This is another question of philosophy of law. Of course, this is the legal theory and the practice are in one way. Absolutely. Yes, 8% of business ethics.
Okay. Yeah, 2020 already 80% of business ethics violations are caused by AI. How can we prevent AI and algorithms from increasing this number?
Yes. I am a jurist, and I suggest a legal remedy. But a legal remedy is not only positive norms. It's not enough the GDPR. We can apply the GDPR, and the question is, how can we prevent AI and algorithms from increasing this number? Of course, we can prevent this if you use not only a legal shield that is only a norm. It's necessary to use a concrete legal remedy, a practice, the application of this. And I think that a legal remedy is the fair play in the sense of I must create a legal proceeding to limit the use of AI and to limit the use of algorithms. But algorithms are a sort of sequence of rules that are not in the power of technology. Technology with machine learning are going to a sort of a free algorithms, a sort of free bots, because machine learning realizes the free robot. And this is another question, very important. Freedom of robots is the real legal issue of the futures, because robots in AI is more free, is always more free, and is increasing the number of algorithms is increasing. And I think that we prevent it if we are jurists, of course, in a legal way. But this question is a cross-disciplinary question. I must create a team to study this. And in the European Union, we know that, of course, this way of thinking, unfortunately, is not present is not the real way of jurists, but I think that this is the way absolutely of future. Absolutely.
So we have the next one. Can one still save his data from becoming part of big data nowadays?
Another question, very, very interesting. Still save his data. Yes. The real question today, another important question is not big data, but the small data. The small patterns is the important part of big data. And the small patterns, for example, for jurists, the small patterns are the legal sources or the legal sources of our argumentation. And this is small data, not big data. But big data in GI are ruled not by humans, are ruled by AI, are ruled by artificial intelligence. The first example of this is the paradigm shift of Google Translator. Google Translator is in origin a logical form of translation of letter of words. Today, AI and machine learning has changed Google Translator, and Google Translating is a sort of world of argumentation, of semantic, of use the digital semantic, and the singular data from part of big data, of course, is very important. I must save my data, not my personal data, my data, my memory. This is very important for this, because big data create a sort of I don't have the word, a sort of no memory. There is no memory. There is we can forget our memory. We can forget our memory if we use big data. Small data is very important in law, because law is the reign, the sovereign of memory. It's the art of memory, the ancient art of memory is ruled by jurists, absolutely. Another question, thank you.
All right, you said every AI can be tricked by counter arguments, or if fed with big data in another direction. Will AI ever be able to play a fair role in legal systems?
Yes, I hope that AI can be able to play a fair role. This is very important in ODR. In online dispute resolution, we have the third party, and the third party, I repeat, the future of trials are in ODR, in my opinion. We can say that in United States of America, in the United Kingdom, there are many experiments about this, many tests about ODR. ODR is just in the European Union. There is a platform of UR, of course, for specific controversies, but I think that the third party, the judge, when the judge is a robot, must be able to play a fair role. I don't know that is possible, but AI must be in this direction, and it's very difficult because the logic of AI is a mathematical logic, a math logic, a formal logic, and maths is not. We can not apply maths in or formal logic in law, because law is a dialectic, is a rhetoric word, and argumentation, for example, is a typical way of proceed this in legal system.
Then
we have another question. Yes.
Yes. Is it possible to use the right to be disconnected without deciding completely against using modern technology?
But it's very interesting, this question. Yes, I don't know the right, because I think that in a legal system we must protect the right to be disconnected. Of course, it's impossible to realize this event if I ask the right to be disconnected. Of course, this is natural, because the legal system is valid if I protect also the right to be disconnected, because the right, the due, you can say on the contrary, the duty to be connected is against human rights, against the human freedom. Absolutely, I must have the freedom to be disconnected. I don't know if this completely against using modern technology, because technology is not only informatics, but is very influenced by informatics. But technology is not only this. Technology is not only the use of a personal computer, of a social network, etc. I think that it is possible to use the right to be disconnected, in conclusion, not against using modern technology. Today we have open issues. I said AI open issue and GI open issue, and in GI open issue, I think that this is not totally in conflict against modern technology.
Okay, then another question. In your view, could AI be an instrument to achieve more equal judgments?
I don't read the word because I have a problem with my screen. More. Oh yes,
Okay.
one more equal judgments. Yes, because
Yeah. All right.
Yes. Anyways, okay. AI is an instrument to achieve more equal judgment today. Yes, because today there is an important field of research in the best, of course, legal scholars that studied this. Algorithms in judge, algorithms in equal judgment. Yes, equitative algorithms are the field of our research. I think that it works if we create a cross-disciplinary team of search. We must insert lawyers. We must insert in this group of scientific search, informatics, technology experts, philosophers, etc. Absolutely, this can be an instrument to achieve more equal judgment if I study and use AI in the new paradigm shift. But it's very difficult. It's very difficult because I think that there is a question, a conflict of methods. I wrote about this in a paper in the Journal of Ethics and Legal Technology. This is principally in Italian, but there is an abstract in English, and you can read this.
Perfect. I think we're done with questions. There's someone saying that it's great that there's such a place for further discussion of it. We're glad.
Okay.
Yeah, that's it.
Thank you. Thank you very much. Thank you very much. Absolutely.
So, can you hear me?
Yes.
Okay, great. So thank you all for attending our talk. We hope you enjoyed it, and then from now onwards, you can take advantage of all the things about this topic that you didn't know before. So thank you, ladies. Thank you, gentlemen. Thank you, ELSA Italia. Thank you, ELSA Deutschland. And thanks again to all who were with us today. We hope to cooperate with you very soon again. Bye.
Bye.
Thank you. Bye.
You so much.
Bye.
Have a good day, everyone. It's been a pleasure having you here and talking about the topic.
Thank you. Thanks to you
Thank
too.
you very much.